There is nothing, central government has nothing to do with this issue. State government as a constitutional body has nothing to do with this issue. The president of a political party who happens to be the chief minister of the state is the accused. I don't believe that Dr. Singhvi is not aware of that distinction. But I understand that's his contention. Available to him, he has raised it. But Article 19 has no place in fact situation of this nature. It's only 14 and 21. My right to be proceeded in accordance with law. And when I say my right, means my officers. When I say my right, petitioner number 2. And when I say my rights, all the petitioners in the second petition.
So therefore, you are asserting your fundamental right in official case.
Yes, Pallav.
So fundamental right can be in personal case. In the context of official privacy, we don't know whether such right can be asserted. The remedy will be different.
No, there is no remedy.
So therefore, the question was asked to Mr. Subal, that the fundamental right are person-centric.
It is person,
or may arise in a different context of this.
I am putting a question to myself. If I am
the third dimension that you are now asserting the right in official.
No, Lord, I'll answer that question. Lord, if a lawyer finds something being done to him under Article 14 or 21, merely because he happens to be in his discharge of official duty, would he cease to be a person? There is no distinction under the Constitution, but I'm sorry. There is no distinction. What would happen whether as a person or as an officer? I am facing an investigation by an agency. The Lordships have seen which agency. As a person or as an individual. An individual who happens to be donning a particular uniform. Lord, police officers do come before your Lordships. That this is the way we have been treated. Lord, if this view is taken, Lord, suppose a police officer in his discharge of his official duty is, say, dismissed or suspended. Then he is suspended as a police officer, not as a person, and therefore he can never file a petition under Article 226. Because then we will be closing doors of justice. The access of justice would be denied. So kindly, imagine a situation. Forget the facts of this case. A police officer in uniform for having done something or having not done something is placed under suspension, and he approaches either this court or the High Court. If his capacity as an individual is different and his capacity as a police officer is different, he can never approach for his fundamentals, which in my submission doesn't born out from the constitutional principles.
You mean to say these two characters are inseparable? An individual who is an officer has to come individually asserting his rights as an officer or in service law or whatever, in criminal law.
He may be facing an illegal act in his official capacity, but the impact and the consequence would be on his person. But my liberty would be taken up. It's not the officer's liberty which is taken up. It is the individual's liberty will be taken up. If I am falsely implicated in an offense, maybe the genesis is because I am an officer of a particular department. But the impact or the final effect would be on my individual. If we would be trading a very, very hazardous line, and we would stop access to justice, if this is separated. So, that is my argument. Another argument raised was Article 131, that this would be a case of a dispute between the center and the state. First of all, on the face of it, there is nothing, central government has nothing to do with this issue. State government as a constitutional body has nothing to do with this issue. The president of a political party who happens to be the chief minister of the state is the accused. And officers of enforcement directorate who happens to be working and they drawing salary from the central government are on one side. Union of India has no issue with this. State of West Bengal may support them, but they have no issue with it. It is preposterous even to argue in facts of this case that this would be a case under 130. So there is one judgment, my lord, which I would. In the written submissions, my lord, there is not a judgment, my lord, it is a contention that even if it is traceable to 131, then only it has to be between union and the state, not a department and the state. Otherwise, my lord, what happens? My lord, suppose a dispute between, say, tax department of the union and not. We have quoted the relevant part, but if you want, we can give the copy to them.
I don't know what to answer because they have given only quoted paragraphs of the judge.
I shall give it.
So give us the compilation so that I can answer it.
Yes, sir,
He said I haven't made it, that's why I'm saying. I'll give it. Thank you.
You have other copies.
Yeah, copies. Then that's what I wanted.
No, he only said we have not given it to the court.
Yeah, but
that's what
it is, I think.
But that's okay. It's too, between us, it's too small a thing. Even if we don't rely upon, we can do it. There is not. So, the department of the government having a law and order issue with the state functionary can never become Article 130. Article 131 issue is completely different, where there are federal issues raised, where there is genuinely a dispute between state as a constitutional unit and union as a constitutional unit. Say river disputes, other port boundary disputes, etc., etc. This is an argument of desperation that please don't enter into the merits of the case because the facts are very, very embarrassing. And the last, I don't think that submission was, I hope was not raised with seriousness. That matter should go before a constitutional bench. Day in and day out, whenever 32 is filed, we raise the contention as respondent that 32 is not maintained. Would that, I'm posing a question to myself, become a question of substantial question of law where 5 honorable judges will have to spend time? There are a large number of cases where 32 is filed day in and day out, and we do raise a contention. But it is always, your lordships, in a sitting in combination of 2 honorable judges or 3 honorable judges. So to say that this has to go before a constitution bench may not be a. So my respectful submission is to summarize my argument, and then your friend will argue. Lord, ED in representative capacity, petitioner number 2 in his own capacity, personally as well as officially, and other petitioners in, again, personal as well as official capacity as citizens of India are before your lordships, seeking their fundamental rights under Article 14 and 21 with a prayer that whatever has happened to us be investigated by a neutral investigating agency, and whatever we are being accused of by a very engineered or orchestrated FIR filed by the accused themselves, be also simultaneously clubbed and decided together. So that is the respectful submission. My learned friend would